Welcome to Human Risk, a podcast dedicated to the understanding of human behaviour as a risk. Here's your host, Christian Hunt.
Hello and welcome back to the Human Risk podcast. On this episode, I'm exploring an innovation that can help mitigate human risk. When I tell you that it involves comic books, in other words, cartoons, then you might rightly question my judgment. But bear with me, this is clever stuff. So how can comic books help mitigate human risk? Well, if you think about airline safety cards, coincidentally the theme of my human-risk.com website, you'll have some idea. Those cards are a graphic distillation of a complex set of instructions that are designed to make it easier for people to do the right thing in an emergency situation. My guest on this episode is Camilla Andersen. She's a law professor who, thanks to a story you'll hear on the show, came up with the idea of comic book contracts, essentially turning legal contracts full of words into simple pictures and minimal dialogue. The obvious benefit of that, like airline safety cards, is that you make something complex more easily understandable, both by people who might not have the literacy or technical skills to read and understand traditional contracts, but also by those who could, like many of us, have better things to do than wade through tedious documents. But there are far greater benefits than just user-friendliness. As Camilla explains in our conversation, it also changes the way lawyers approach contracts and perhaps surprisingly leads to significant improvements in organisational culture. Stay tuned to find out how. I think this is a really exciting idea that has applications way beyond legal contracts, and it's something I've already started working on with some of my clients in their ethics and compliance programs. Before we begin, a warning that our conversation does contain some fruity language, so be warned if you don't like swearing or have little people within earshot. In keeping with the comic book theme, this is a really fun discussion, so please enjoy, as I am absolutely sure you will, my conversation with Professor Camilla Andersen on comic book contracts. Camilla, welcome to the Human Risk podcast.
Oh, thank you so much, Christian. It's great to be here, and I'm looking forward to seeing what you want to know about my work and my research and generally what we do.
I am super excited. So thank you for joining us. And to start us off, can you just tell my listeners a little bit about yourself and your area of research?
Yeah, sure. So I am an academic in the law school at University of Western Australia. I've been here for 8 years now. It's summer and 45 degrees outside, sweltering. So those of you listening in January, sorry. I chose well coming down here. But on a less personal note, what I work with at University of Western Australia is I am the project leader of a large research team called the Comicbook contracts, deliberately so named because what we try to do is provoke the idea of contracts having to be in a certain way. We put images and visuals into contracts to make sure that people comprehend them, so understand them, engage with them, so actually read them, and take part in the whole contracting understanding process. And we also look at the perception of these contracts. So how do people feel about companies or institutions that hold up comic book contracting? How does that actually impact on the company that does this? So those are the three prongs of the project. It has exploded over the last 6 years. This is not what I used to do. I came down here as a very renowned black letter, boring old lawyer doing international commercial law, uniform law, trade law, carriage of goods by sea, all that stuff, and comparative law, which is relevant because I think the fact that I work with a lot of different legal cultures is probably one of the things that's driven me over the edge into this weird and murky territory of comic book contracts. But once we set up the first contract, which was just a favor for a friend in the School of Engineering, where we designed this UWA makers contract with a non-disclosure agreement in comic book form to try and make sure that the engineering students actually read it and didn't pose a liability to the industry that they were collaborating with for credit. Once we did that, the media went wild. We were on ABC Law Reports. And suddenly, something that never, ever happens, and if there are any academics listening, they can certainly attest to that, people started knocking on my door with checkbooks, asking me how much I wanted for them to sponsor my research. I'm like, what? Where's the hidden camera? But it actually happened to me several times in a row. So it dawned on me that I was not the only one who thought that there had to be a better way of producing legal documents for people to actually read and understand. But visuals are a fantastic advantage, a tool that for some reason the law seems to have forgotten about. And that not only should we be driving better comprehension of contracts with plain language, but we should be looking at the behavioral drivers and what to do to eliminate disputes in contracts. There's a lot to say about this, and I'm sure we'll get to a lot of different aspects of this as our conversation proceeds, but I would encourage anyone listening to have a look at the website, www.comicbookcontracts.com. There are a number of exemplars there. Because if you think it sounds weird, you're not wrong, and you're certainly not the only one. But once you have a look at some of these contracts, you'll see that they're actually quite pragmatic. They work, they're functioning, they're not as patronizing as it sounds. And it really is just about driving comprehension, not just for those who can't read. My colleague Robert DeRoy in South Africa has won a number of awards for access to justice for his contracts tailored at illiterate fruit workers and domestic workers, but also for those who, let's face it, can't be asked to read. Those who wants to rifle through 65 pages of legally gobbledygook, when you can just have a quick comic book that tells you the most important things you need to know. Basically, the way I see it, if I give you the 65 pages, you're not going to read them. You're going to sign every single highlighted X in the contract and absolutely have no idea what you've just signed. Or I can give you the simplified visual version, which, yes, does eliminate a lot of different aspects of the contractual obligations that you will be signing, but is a much clearer and much more accessible and engaging behavioral driver for the relationship that you're going to be in. So you tell me which one you prefer. Now, the really interesting thing is, over the last 6 years, we've been monitoring these very carefully. I am a researcher after all. We've been looking at the comprehension, off the charts, much better comprehension on image-based contracts. We've been looking at the engagement. People enjoy this much more, and they actually read them. Fantastic. And we've been looking at the perception. Do people feel compromised? No, surprisingly, they don't. Do they feel patronized? No, they don't. Do they feel that this is a bad idea? Most of them don't. We had over 2,000 different focus group members. We've only had one slightly negative response, and excuse me for being a bit lippy about this, and you're welcome to edit it out if you find it offensive. But the person in question identified as a young male between 19 and 25 and left the comment, and I'm paraphrasing, yes, this is not quite intellectual enough for me, but I'm sure most of your customers will find it satisfying. Now, I know this young smart ass. I probably teach him. He will grow up and get better. So, other than that one negative comment, we've only ever tested positively, and drumroll at the end, we have had zero disputes of any of the contracts we rolled out over the last 6 years, not a single one. We were all very sure that when we hit mainstream, as we did when we started doing banking contracts for Bank West here in West Australia, then that statistic would be eliminated, but it hasn't. There are big dust bunnies accumulating in the customer complaints office at Bank West because customers now read their product schedules. One of my favorite LinkedIn posts going viral at the moment is someone whose name I've never seen before, who's posted a picture of his comic book cartoon product schedule with the comments, "Here's the first product schedule I have ever read. Well done, Bank West." Yeah, scary.
Wow.
Read their product schedule.
So look, I love the passion for this stuff because this plays exactly into a key theme that I look at, which is I think things are made unnecessarily complex and tedious, and we all go through, frankly, what is an act of major dishonesty, right? Which is we all sign things or click on things that we just haven't read, right? Whether it's terms and conditions for software or renting a car. We've all done that thing, and we've all done it both in our private lives, and we've also all done it in a work context where you kind of go in there and go, well, I have no choice. I'm going to have to sign this damn thing to get to whatever it is I want to get to. And so I'm just going to go through this process. And what you've basically done is said, actually, there is another way. Yes. And that other way here is let's have something that is clearer to understand. So as you point out, helps people that might not have the reading abilities and capabilities to understand it, and helps people that can, that do have the comprehension abilities but can't be bothered to read it because frankly they have better things to do. Yeah. And so you're literally taking us to a world where we're being much more honest about an exercise that is fundamentally dishonest, right? And the dishonesty around the exercise I see is companies, the company that's imposing this knows that we're not going to read it. We know we're not going to read it. And so we're all reliant on some kind of, let's hope things don't go wrong. And if they do, we'll get into the weeds of this thing. But it doesn't make anybody feel good. And so what I love about what you've done here is you've debunked the big myth that it has to be that way, right? This is handed down on stone tablets. This is the way we have to do things. And you've basically gone, there's a better way.
And I think there is a better way, but I think one of the most important words that you said at the beginning was you're talking about unnecessarily complex. It's that necessity that we really need to unpack, because there are some contracts which, because of their nature and because of the risk averseness of the actual parties involved, not the lawyers, but the parties, might need to be quite complex. I think they can still be made clearer with visuals, plain language, good design, don't get me started. But the complexity of a contract really depends on what need it's supposed to meet. And the necessity of complex contracts is something that we really need to shine a spotlight on. Because the vast majority of standard form contracts, or contracts that people have gotten used to using, as you say, handed down on that stone tablet, are complex because something's gone wrong, either historically or for someone that they heard about once. And lawyers are scared. They're risk averse. And so they put clauses in to try and prevent that from damaging their client, which they perceive as their duty. And look, fair enough. But what we've ended up with in the vast majority of the disciplines that we've looked at are contracts that are so unnecessarily complex that they tailor for the 0.001% of things that may possibly go wrong one day, but probably won't. And where's the sense in that? Where's the sense in not just catering to the 99.9% of contracts with clear behavioral drivers to avoid the majority of the sort of the most pain point identified disputes? And I'd love to talk a bit more about those pain points because I think they would really interest you, Christian. But cater to the 99.9%, forget the 0.01%, because honestly, hand on heart, lawyers, if you're listening, you're not going to be able to think of everything anyway. And the really belligerent individuals who are going to want to sue you, they're going to find a way anyway. So just go ahead and make your contracts clear, understandable, and workable, unless, of course, you are in that small niche where that's not really what suits you. You need something complex. But then I'd still encourage you to think about the fact that maybe there is a better, clearer way of making that complex more accessible. Because the big question is, if we've got lawyers creating contracts for other lawyers, other parties even party to the contract, drum roll. So people might be signing them, but if they're not signing them and the only person who really knows what's in that contract is the lawyer, who's that contract really for? And why is it that law hasn't been forced to get a language interface or a communication interface for its users? Just like medicine and all the other disciplines where communication in a specific science is a discipline. We just don't have that in law. How did we get away with that? There's a real head scratcher. But I think we can change it.
Yeah. And I love the way you talk about that, because if you think about any other form of communication with a customer in many cases, or an employee, whatever, we do instruction manuals. What's the trend towards? Well, let's get rid of instruction manuals entirely if we can. If we think of something like an iPhone, we don't need to have an instruction manual. But if we do need to, we put pictures in it, right? We make it idiotically simple for people to use. And the best products that we tend to like is stuff that we can get to grips with relatively easy. We understand, we have clarity of what's going on.
Yep.
It's the antithesis of what you talked about.
Yes. Well, I've been to a number of public speaking engagements, and I received an award a couple of years ago, a lovely little gold coin from a law association. And somebody actually stood up and accused me of dumbing down the law. And at the time, I was a bit aghast. How can they say that to us? We're working so hard to try to make the complex simple. Blah, blah, blah.
It's an award for treachery, right?
It's a jihad on me from the law society. Actually, we can get back to that because there isn't. But then, you know, how it always is, you come home and you think of that clever thing you should have said. And what I should have said, and this was fed to me by my husband, who, by the way, runs the commercial arm of the research project, Alternative Contracting, plug there. He said, well, how can it be stupider than people not reading it at all? I mean, how can you dumb down something which is completely ignored? Surely anything you create that makes people engage even a little bit is an improvement on the incredibly dumb version of being fine with nobody reading it.
Right, being slightly informed is better than being not at all informed.
Well, I think that's the theory anyway. Let me know what you think. If you were managing your risk, wouldn't you like to be knowing a little bit about what it is? But it's a really interesting thing, and there are always going to be, especially lawyers of a certain generation, who feel like we're dumbing down the law. And when I say a certain generation, I'm not being oldest, I'm being youngest, because it's the young, the freshly educated sort of about maybe 8 to 10 years into the profession, who have been doing things a certain way, who are very intelligent but not necessarily wise, who are really scared about changing the way that they've been taught to do things. And look, I understand that. This is potentially quite a scary thing, because we are facing the kind of risk that lawyers are being trained not to take. But by catering to the most common, the middle of the road behavior that tends to cause the most problems, and we identify that very carefully in all of our projects by doing sort of pain point assessments and risk analysis of the real shop floor issues, that I think you'd be very interested in that stage of the process, because we work closely with psychologists on that. One of the great things about being an academic is you get all these amazing professionals just around the corner at different parts of the campus. So yeah, we work with whoever we need to work with to identify those pain points for every contract that we look at. So whether it has to be somebody who's an expert in finance for a banking contract, or an engineer for a construction contract, or whatever. And we almost always have our psychology team on board as well to try and help identify whatever behavioral drivers will help to minimize those problems. And more often than not, and I'll provide you a picture of that from the Oricon contract, which is an employment contract, which is entirely online, now rolled out across 7 different jurisdictions for Oricon, which is a large engineering consulting company. That employment contract introduces things that weren't in the old bundle of contracts and onboarding and compliance training. So that employment contract incorporates compliance training in the employment process. So the contract itself has links and training and information on all the things that are obligatory and statutory in a comic book format, but it also introduces things that weren't there before. The example that I often use is that of timesheets, because it rings true for lawyers as well. So young engineers don't understand that they need to fill in their timesheets on time so that the company can bill the client. It sounds so banal when you point it out, but they don't think about it, and that's fair enough, because where were they taught that at university? They weren't. But now it's in their employment contract that they need to do this, and so we've been monitoring this very carefully, and human resources tell us that over the last 5 years after this, they've gone to this, so 4 years now, after they've gone to this comic book format at Oricon, this particular problem has more or less disappeared. Because the issue, here is why you need to fill out your timesheets, just do it, it is eliminated because it's flagged up so early in the onboarding process. So it doesn't take time to be a problem.
And the bit I find really, really interesting here is that if you take a risk-averse approach to life, and you sort of go, right, the reason we need these ludicrous contracts, they would never use the word ludicrous, but you know what I mean, right? The reason is these hefty, these comprehensive, let's use a word that sort of that they would use, comprehensive contracts, right? It's to cover all bases.
But you can't be like, how can you do that in life? It's a ridiculous philosophical proposition.
Well, COVID's a brilliant example of stuff that we probably, we wouldn't, like, and it wasn't unpredictable, right? So if you look at something like COVID that was at least theoretically predictable, and that wasn't fully contemplated in all these situations, that's issue one. And then issue two, it always struck me, if you make something incomprehensible, unattractive, unappealing, people aren't going to read it. And so actually what happens is you get a combination of people that are willfully trying to break the rules and people that genuinely haven't managed to find the thing, are put off by reading it. And you lump all these people together. So the willfully non-compliant are lumped in with those who are accidentally non-compliant. The people who would ordinarily do the right thing, but because you've made it unappealing, complex, impenetrable, can't do it. And so actually what you're talking, it's actually less risky to make it easier to be compliant. Because what you then do is you say, okay, if I've made it crystal clear to you, and it's blindingly obvious in a format that you can easily understand, and you still choose not to comply with it, then suddenly I've identified you as willfully non-compliant. And I think this is a brilliant way of identifying that, I'll use a very loose term, criminal element there, the wrong-uns, the genuine bad actors. Because at the moment, they can hide in amongst other people that you can say, well, it was a bit confusing. Well, let's make it totally not confusing. Yep. And then anybody that's not doing it, right, there's something wrong with that individual as opposed to there being something wrong with the structure. And I think it's a really helpful tool for identifying the people that you really do want to identify that are willfully non-compliant.
I think that's a really interesting angle, Christian. Thank you. First of all, I've got to interject that I think the willfully non-compliant is, at least in most of the disciplines we worked in, a very, very small sub-percentage of people who come into contractual disputes. The vast majority of contractual disputes are unforeseen circumstances and misunderstanding. So I think it's very rare. But the cool extra dimension on this is that our project fits beautifully in the realm of relational contracting. Now, for those of you who are not familiar with relational contracting, this has been out since the 60s, but really hit its stride when a Nobel Prize was given to the Swedish and American team who undug it and reanimated it by proving the economic efficiency of relational contracting. And the concept is very simple. By making a contract much simpler and about the relationship, it's so much easier to ensure compliance. Because as you say, there is no sneaky mind that can get outside the really broad strokes of the concepts of a good moral relationship. But there are lots of loopholes in conscientiously tight-knit contracts. You're always going to find a slippery loophole if that's the kind of contract you've drafted. But by drafting something which sits on certain ethical, moral boundaries much more clearly, it's going to be much more hard to find a loophole. And it's also very efficient because you don't spend billions drafting and all that. So I've actually got one of my postdocs is currently proving the legal efficiency in law and economics. Now she's a Chinese student from China with an economics degree, and she's now proving how economically efficient these contracts are. I predict that'll make them sell better. What do you think?
So look, I want to come on and sort of explore the process. And before we were recording, we were talking about the fact that obviously this is the irony here is we're talking about something very visual and we're doing it in an audio format. So there are links to all of these things in the show notes. So as we talk about some of these things, we're going to put links to your websites, but also content there. But I just want to explore. So the question that people were bound to ask and say, well, has this been tested in a court of law? So I just want to sort of talk about some of the limitations and get that out of the way. So has this stuff ever been tested anywhere?
So if you were listening, Christian, you would have heard me say complete dispute elimination. So we are currently waiting for disputes to come up in these contracts that we have drafted, but we are the victims of our own success. There are no disputes. We honestly thought that once we went into mainstream banking, I mean, there are over 250,000 contracts with visual comic book product schedules now out there. Not a single dispute. I wouldn't say I'm disappointed because part of me is really happy that we can still maintain this amazing statistic. But the other part was also hoping that we would finally get these tested in a courtroom. But instead of testing them in a courtroom, what we have done is we've got the Chief Justice of Australia, former Chief Justice, now Robert French, who gave the closing address at the 2017 Comic Book Contract Conference, saying, of course, these contracts are binding. The real difficulty here is interpretation. And he's absolutely right. And that's why we're trying to be incredibly careful. We're not trying to develop a complex visual language that only lawyers understand. We always...
replicating the written formatting kind of thing.
It's harder for anyone to understand what's going on. It's the opposite we're trying to do, right? So we always try to make sure that our images are right for the region, for the culture, for the age group, the demographics, and the industry in question, which means we...
Do you know what that reminds me of? Sorry to interrupt you. It reminds me of, those labels you get in clothing that tell you how to wash it, right? Which in theory makes it simpler, but they actually have to explain to you what the little icons mean and thereby undermine the purpose of it. So that's what you're trying to avoid, right? You want to get to a stage where it's self-explanatory and works on its own.
Possibly. I mean, one thing that I'm sure your listeners don't need to know about me is I haven't done laundry since 1998 because I have an amazing husband. So I haven't seen those labels.
For any listeners that haven't seen them either, I will put a link to those in the show notes.
But I'm sure it's a great metaphor because I actually don't believe that we're anywhere near being able to try and advance a one-size-fits-all imagery for contracts. I don't think that's a good approach. I know that there are a number of different sort of image banks and different innovative legal services and support organizations that are trying to get to that, to eliminate the cost of creating these images. And I think there is some value to that for sort of very limited ease of understanding and design. But what we're trying to do is much more comprehensive than that. We're actually trying to develop behavioral drivers with images, and they do require a bespoke approach. Is it expensive? Well, again, how long is a piece of string? It really depends on what you expect. I mean, one of the links that I'll provide you with is for my husband's website, alternativecontracting.biz, and he has created a contract from scratch for a small one-man sole trader handyman service. Have a look at it. It's Dave the Handyman. It's one of my favorite contracts. We collaborated at the Comicbook contracting team with my husband on it so we could write about it. It's sneaky that way. It's just one page. And if you look at it, it's got the handyman's values, his basic expectations, what he wants, what he needs, what he promises in terms of a warranty. And, what happens if he uncovers something unusual in your backyard, then the project might be delayed. In the image, it's a dinosaur skull. And it doesn't limit the surprising circumstance to dinosaur skulls. It's just a humorous illustration of something that probably won't pop up, but represents that surprise. So that's all it is on one page. Then his bank account, his payment terms. I loved working out that contract because it took less than a week. There was no previous contract upon which we based this design. That's what takes time. And I'll talk about that process in a minute because you were asking about our processes. But it was so fast. The illustrations are really very simple, and so they weren't expensive, loving that. And the whole thing was less than $2,000. So, drafting a contract with minimal legal advice from scratch with images bespoke for that industry, bam, it does not have to cost an arm and a leg. It can cost an arm and a leg. I refer you back to the banking product services. They were very expensive. And at the moment, is one of my personal gripes at the moment is I've got a number of sponsors, much smaller scale sponsors than the bank, going, why doesn't my contract look like the Bank West one that you did for them? I'm like, well, because it didn't take 3 years and it didn't cost $150,000. So, I mean, these contracts look like whatever you pour into them in terms of what you spend on graphic artists and new image generations and all the things. The more money we pay for graphic art, of course, the better it's going to look. But you can accomplish something really effective relatively simply. And I'm not saying that lawyers have to learn to draw. You can get someone to do your drawing for you. I'm also not saying that lawyers even have to visualize what kind of image works best to convey a certain situation. Some of the illustrators have been trained in visualizing specific behaviors. Some of them have training in things like live drawing, where they hear words and then they immediately come up with images that most people would associate with whatever it is they're hearing. So here's a shocker, and I hope you're sitting down, listeners in the law profession. Turns out that lawyers are not the best at everything.
I'm going to have to edit that out. I mean, that's not going to go down well.
I know it's not going to go down well. But there are things that other professions do really well that we could learn a lot from. And my project wouldn't be able to do anything without that interdisciplinarity. It really is key. So accepting that legal communication should be a thing, that we need to learn to communicate better, not just about law, but in law. I think there's no limit to what we could do if we were just humanizing our profession a bit better. And we can learn from other professions who do this really well. I'm not saying...
Can I just unpick that no limits thing? Because it struck me. So as I was thinking about, well, where wouldn't you use this? Well, the answer, it seemed to me that there are certain things. So certain things, I don't know, if you were transporting dangerous chemicals, right, you're probably going to want to have some very specific rules. But yet the way you communicate that to the staff who are acting, it might be the health and safety communication might be very, very different. But it struck me that in very simple terms, if the B2B might be more complex than B2C. And what I thought was really interesting was, as you were talking, is if your aim is to make this easy comprehensible, if you were to make your cartoon contract 5,000 pages long, you've kind of defeated the object of doing it. So to a certain extent, it's self-policing in the sense of, if it's something that can be compacted down, in many respects, it would be self-policing as to what you could or couldn't use this for. Is that a good way to look at it?
I think so. I mean, one of my favorite projects that we worked on, which took a very different process from the Dave the Handyman, is the WAIS contract for disability support. This is a contract that we did with the registered charity WAIS, which West Australia's individualised services. They try to make sure that people can remain independent in their own home with disabilities for as long as possible. And our job was to try and create a contract for the employment of domestic carers in the home. Really, really difficult legal area, because the definition of a domestic worker is so hard here in WA, and I won't go into the juggling that goes around there. But this project took a lot longer than we'd anticipated, because we had to keep it so simple, because we had to ensure that it catered not just to all the different kinds of physical disability, but also mental disabilities, and also to people who are carers for those who are disabled. And it's a little bit about, like, I've looked this up, and apparently Mark Twain never said or never wrote that if I'd had more time, this letter would have been shorter, which is disappointing because it was such a lovely quote. But somebody caught me on that a few years ago and said, Mark Twain never actually said that. And I looked it up, and apparently he didn't. It's very disappointing. I wish he had.
maybe he never wrote anything, right? It's all just like
just rumor and hearsay, everything. But I'm saying it, it takes a really, really long time to make the complex simple enough to pass all kinds of different standards for different users. And what we did here was we did a very comprehensive risk assessment, looking at the actual audience, a series of focus group testing with the actual people who would end up being in the situation of having to use the contract, And there are so many images here that just hit the cutting room floor. We made so many mistakes. So Su Tian Li, who was the leader of WACE, and I have written a really interesting paper on all the mistakes that we made, which makes for a good read if you want to know what not to do when doing a visual contract. And it is a very steep learning curve. And taking away from that, know your industry really, really well. Understand what visuals resonate with your audience. And the more diverse your audience, the more difficult that's going to be. Understand very thoroughly what you want to get out of this contract. Understand the values and the relationship of what it's meant to be. Because the moment you embark on visuals, you are embracing a whole different, almost a spiritual side of communicating with people. And it can resonate on so many different levels. So you've got to be really careful what you're drawing. One story that I'm happy to share with you about our mistake is that we had 4 different colors in the WACE branding spec. And one of them, so there was teal, orange, brown, and pink. And we used pink for the carer just because it fitted nicely on the avatar, as we call them, the visual representation of the carer in the contract. And the first focus group testing, I was actually called a misogynist pig by one of the focus group users for thinking that all carers were women. I was like, oh, okay. I'm also a woman. Hi. Never mind. But it was just such a slap from somebody who thought that I was assuming that all carers were women just because we were using the color pink. And so you see that clear association with the color pink and the vitriolic hatred of it. But it wasn't just the one. And once we had that sort of vitriolic feedback, we could then tailor questions to the focus group. And many of them actually thought it was really weird that was a female. It's not. It's clearly a gender-neutral avatar. It's a little scrolly with legs. I can send you some pictures afterwards. You can put in the comments. But yeah, there's that association. So I've learned to be very afraid of the color pink and numerous other mistakes. So all of this process in trying to identify what it is you're trying to communicate, such an important thing to be really careful with. And the wider your audience, the more difficult it gets, but also the more worthwhile it is, because it means that there is a difficulty in communicating evenly to everyone, and it's a job that's worth doing.
That's really interesting, because that illustrates that you're playing on a very visceral level. If you provoke that kind of reaction, you are getting to people, and I mean that that can play positively and negatively, and you're therefore engaging people in a way that the written word probably wouldn't. And I was thinking of your example of sort of, we have to be very careful about his and her and
Yes.
pronouns that we use in contracts to make sure that we've covered both. Whereas this, actually, that's a really interesting sort of reaction where you sort of go, well, I've reacted against that. Okay, well, that, and you joke about, well, don't want to read about mistakes. Let's find out how to do it rather than how not to do it. But actually, discovering that, I think, illustrates the power of what you're trying to do, because you've provoked a reaction in someone, and it's a little bit like, good advertising provokes a reaction. That is illustrating that these techniques work, albeit that you want to get that sort of thing right.
But it also underlines, and thank you, I think you're absolutely right. It underscores the level at which you're communicating once you use images. It's at a completely different level, which is why it sits so well in relational contracting, because it helps you to establish that sort of spirit of the relationship with images. But it also really underscores the importance of getting it right. And it's definitely difficult to do anything but bespoke, I think. Because we want to avoid that standard meaning in images. So it comes down to what Robert French said at that closing address. It comes down to that interpretation of images, which is why we so carefully focus group test everything we create, because we want to make absolutely sure that it speaks the right language to where it's being sent. And it's not just the industry or the contract, like the Oricon contract that I talked about that's being rolled out in different countries. Some images don't speak the same in different regions. Like my favorite example is there's in the maternity section of the employment contract, lowest common denominator, we use the stork. Bringing a baby, that's nice, right? Nice and neutral. There are certain images you certainly don't want in that contract. So let's see the baby's arrival with
Where does it come from? Let's illustrate that, right? Yeah.
Sure. There you go. That's nice. But in certain regions where they were rolling this out in different countries, the feedback was like, why is the bird abducting the baby? What? Because that's not an image.
The bird could have stolen the baby, right? It's like an awful scenario, right?
So, a classic one. So even the same industry, the same company across different regions of the world, you need to reinvent those images because they won't speak the same language to different users. with different cultural backgrounds. And it's so important to get that right. And I was kicking myself, Christian, because as a comparative lawyer, I've been saying that about words since day one for the last 30 years. And then making those mistakes in images, I was like, oh, right, well, now we know. But yeah, it's the mistakes that we make that we learn so much from. I feel like I'm doing sort of a Disney's The Robinsons, celebrating each mistake as we go along. But that's the joy of being a researcher, right? I get sponsored research to try and make mistakes, and then we fix them, I hope. And we hopefully lead the charge for change.
You've touched a little bit on the process itself,
yes.
right? Which clearly there's a whole effort. And you talked earlier on about this idea of distilling it down to what is absolutely necessary.
Yes.
How does that work?
I haven't had a single project be the same in terms of process yet. They're all very, very different because it all very much depends on what the sponsor wants, what they're hoping to accomplish, and also what they're willing to give. I mean, I've learned now to say no to sponsors where one part of the company is very keen and the other part is like, yeah, we're not sure. I'm like, yeah, come back to me when you're all happy because I don't have the time or the patience to convince those of you who are not. So you all need to be on the same page. I don't want lip service change. I want actual change. So, and I give them this whole spiel about how this is going to change not just the way that the contract looks, but the way that they're actually going to be engaging with this contract. It's more about the relationship with it. And if they're not on board that, then lucky for me, there's a queue outside the door, so we're good. So I'm sorry, that sounds really bitchy, but it's just...
That resonates with me hugely because I have a similar thing when I'm talking to people about kind of bringing behavioral science to compliance.
Yeah, it's the same thing.
I don't have... There's so much effort involved in making this happen.
Yes.
Things you need to think about that I don't have the bandwidth to also win you over. And so if there's so much, I'll find a path of lesser resistance because, as you say, there's enough other people out there. So I completely recognize what you're saying. And it's kind of like, if you, it sounds bad because like, if you don't understand this, I'm not, but it's like, you can't make it happen if you've got, it's almost like friendly, I'll put it sort of in this friendly fire, right? You need to have everybody on board with that thing to be able to get that.
We have survived projects where we did have a lot of internal resistance. And I'm proud of having survived that and not doing it again. So, yeah, it's just not worth the hassle, honestly. So, yeah, what I'm finding now is that I'm usually now sponsored by the marketing and branding departments because it's the marketing impact of this transparent law is suddenly being noticed everywhere. So people are loving clear, identifiable rules. And the larger corporations are spotting that and they're like, oh, let's get some comic book contracts because it's great for our marketing of us. Transparent law is sexy and it's cool and people like it. And that's great. But if the legal department aren't behind it, that's nah.
And that's interesting, right? Because the marketing is a sort of, the marketing's a here and now thing, whereas the legal implications of it will kick in when something goes wrong, when somebody wants to get into dispute about it.
Which nothing has yet, so we don't know what's going to happen when something goes wrong. I think the interpretational aspects of these contracts is fascinating. It's a whole new discipline. I can't wait to teach it, but we need some case law first.
So, talk us through that marketing piece, because that's, I mean, it's, again, this is slightly counterintuitive, right? The last place that you're going to think marketing people probably view legal as a drag. If I think about financial services products, those disclaimers that sort of destroy the artwork, or you've got a radio ad or a TV ad and you get this load of blather at the end that's read as quickly as humanly possible, right? Which illustrates that it doesn't really fit with the rest of it. So you can sort of see that they might look at it and go, oh, that's it. So you've got these people that recognize it's not even like we're removing an impediment. It's actually a positive for them.
It's a massive positive. So BankWest have very smartly tailored an entire campaign around what they're calling less BS, less bank stuff. Very clever. And they're promoting their transparency and their lack of red tape and their efforts to be more clear with their clients. And obviously this comes hot on the heels of the scandal at the Banking Commission here a couple of years ago where the banks were regaled. So it turns out they're trying to make a profit, Christian.
That'll never catch on.
So I'm being a bit flippant about it because I think that the actual commission report wasn't as bad as the media presented it, but the way the media presented it was really quite laughable. Shocking. Banks are just trying to make a profit off of you. Oh, really? But they were very regaled for not being transparent enough and for deliberately wanting to hide terms and conditions. especially in loan contracts. And so the desire to change that perception of banks as perpetually evil has driven a lot of positive marketing around the ease of transparency for those who are trying to be different. So I understand that in the banking. But we've now launched a project with the marketing department here at UWA. And I'm very happy to be working with Sharon Purchase, who runs the marketing department, because she's keen on this now as well, to look at transparent law as an actual marketing tool. And it's a thing because it's sexy. And how cool is that? I mean, maybe we can reduce the lawyer jokes in the world by being nicer. I don't know. What do you think?
I mean, I think this and banking's a really interesting example because you have this asymmetry of information, right? Yeah. So banks know all. If I'm taking out a mortgage, right, I'm doing that once every X years. Banks are doing these things every single day. So there's naturally this asymmetry of information and knowledge and understanding, which, from a negative perspective, can always be exploited. So how do you reduce that? Well, the answer is you try and bring you put the customer in a position where they can understand it, and they're not signing up to things.
Why don't you put a pin in that question and ask me in 2 years' time? Because I think we might be working on something like that.
Right. But I think that, I find this whole piece fascinating because what I like about it is there is a nice ethical component here, which is if you were trying to run an exploitative business, what do? Well, you give the customer as little information as possible. You trap them into terms and conditions that they haven't read, don't understand, won't understand the consequences of. And you kind of suddenly go, we've got them. They're now trapped in our little world. And that's, of course, that is unethical. And so what you're basically doing is saying, let's take that stuff off the table because you can't do that in this world.
No, and there's actually, again, I'm going to wave my super optimistic, quasi deliberately naive flag here and say, even if a company isn't willfully trying to run deceptive practices, if they've got bad practices embedded in old contracts that can be abused by a system of opportunistic workers who then see an opportunity to do that, then that's really not in their own interest. I mean, recently, worldwide, we've seen a lot of, especially small and medium businesses, winning commercial lawsuits against other companies for non-transparent rules, for duress and inequity in bargaining power, which is a complete reversal of some of the fundamental principles of commercial law. We've always assumed that there is equality in bargaining power. I mean, what a crock, honestly. But that's been the legal presumption. Now the truth is out. Turns out bigger companies have more bargaining power and the smaller ones have power in challenging that and can actually win. More importantly, we've got consumers who are fighting back against things like unnecessary insurance terms that they've been paying for years, unnecessary lock-in phone deals and phone penalties for phone contracts. These things are being challenged and appealed, and people are winning, and huge penalties are being paid out by companies who may not have intended to misrepresent, but because they have their own unclear rules, it's never very clear what they really intended, and so that's being used against them. So I would posit that it's in everyone's interest, including the big companies, on the assumption that they don't wish to be misleading and deceptive, that they have transparent rules which are super clear, so that no one can say, consumer or otherwise, you tried to get one over on me. Because I put it to you that if I put a crystal clear comic book contract in front of you where the image clearly predicts what's going to happen if X occurs, then you cannot rock up in court and say, I wasn't told what would happen if X occurred. You can't, because it's crystal clear. It's not hidden in a clause in small print somewhere. You can't win that lawsuit. So it's in everyone's interest on both sides of the fence to make sure that there's clear and transparent communication. So, yeah, it's not just all about being sexy or having the consumers read it. It's also about protecting those that hold out contracts that they wish are properly understood.
And is there I recognize you said that every single project has its own different unique characteristics, but are there kind of big picture differences between, say, an employment contract and a sort of customer some sort of sign up process?
Well, there will be some. Most of the employment contracts we've worked on have some kind of a compliance aspect where there's some training folded in, and we've really been able to make the best use of sort of the digital framework within which law is now beginning to learn to operate. So that's been really good. Where we find it a bit more simple with some of these consumer contracts, where you don't have to fold in training or specific knowledge. We're also working a lot with consent forms, both consents for medical treatment and psychological treatment for various different charities and hospitals and health providers. These are proving to be super, super interesting. And they kind of mirror that consumer angle in that you're trying to communicate as much as you can without trying to sound like you're saying it all. You're creating a relationship for a certain kind of care or a certain kind of product, and within a reasonable framework that, come on, face it, any good judge can interpret what's reasonable in context, but you can't anticipate anything that may or may not go wrong. So within the confines of that relationship, we can try and figure out if something should go wrong, what we should do about it. One of the interesting things, so I'm sidetracking a little bit about the employment contracts, is we're actually seeing them used as manuals. So the electronic ones that we've created, we can see that people are accessing them. They're accessing their own, so we're keeping statistics on this, they're accessing their own human resources webs to look at their own contracts, because the links to whatever job training is there obviously can be refreshed and followed up. The information that is there is what was there at the time of their hiring, and they can see, well, what's now changed and what are actually my rights and what are actually my obligations. Robert DeRoy is reporting that many of his workers on the fruit picking contract with Clement Gold, they literally carry it around in their back pocket so that they have a frame of reference, a manual for their actual work, which is fantastic. So we don't see that kind of commitment to the framework, the contract as a framework for the relationship in the consumer contracts that you talk about. But in the employment contracts, we actually see them as a manual for the relationship, which is fantastic.
That's really interesting, because I was just thinking the only times you would go to your, and this is entirely keeping the spirit of the whole of the exercise, right? The only times you would go to your employment contract is like, I want to resign. How much notice? What's my notice period? Because that's not something you can go in. Because I know this from personal experience, right? You can't go to HR and go, what's my notice period? Because you're flagging up the fact that you're looking at leaving, and you don't even want to search for that on the intranet, right? So you go to the original contract. The only other time you do that is if you're looking for it to hand it to your employment lawyer because you want to take action against the firm. And I love this idea of actually fusing the kind of, in simple terms, fusing the employee handbook and the employment contract all into one thing.
But why should it be two separate things? I mean, that's the whole.
Right.
Why
it's the same. It's the same. It's covering the same thing.
Why do we have to have a legalese version of the common sense product? What is the point of that? Why are we creating something for lawyers to agree on that nobody in the middle who's actually supposed to be bound by this actually reads or understands? It's ludicrous. Let's just focus on making the player's handbook the legally binding document that everyone can understand. Yeah, and you can call it dumbing down the law if you like. I won't disagree with it being dumber than the higher lofty complexes of complex legal terminology.
But the thing I love about that insult is there's a series of books called The Dummy's Guide to, right? Those yellow and black, right? Which sell supremely well, right? This is not some sort of minority. People buy these, right, because they want the answers to stuff. So I would argue that if that's supposed to be an insult, you've got a whole publishing series that's done really, really well that illustrates that may not be a bad idea.
And I actually don't think we're dumbing down anything. We're just making it more accessible for the vast majority of people who aren't fluent in legalese. Shocker.
Right, and they shouldn't be. They shouldn't be. And there's an interesting parallel here, I think, with and this is where I love having this conversation, right? Is an interesting parallel with the compliance thing, is our objective in life shouldn't be to turn individual employees into legal or compliance experts, right? They need to understand enough of this stuff to be able to do that, but their day job is something else. If they were interested in becoming lawyers or compliance officers or whatever,
retrain them for it.
They're right. They'd be working in that field, right? They wouldn't be doing. And so I love this idea. If it's almost like you're basically saying, we'll bring our thing to you, right? And we'll cross over and we'll make the effort to get to you, as opposed to, I'm going to drag you kicking and screaming into my specialist field where you will feel incredibly uncomfortable because it's not where you want to hang out, right? And you won't. And I love that idea of we need to go to the audience and find ways of engaging with them, because that's a much more effective way of getting people to think about stuff and getting their attention.
So if anyone looks at the Oricon employment contract, which has won a great many awards and was one of the first ones that we got out there about 4 years ago, it's available on the Comicbook contract website, and I'm happy to provide you the link for it. But if you have a look at it, one of the things you'll notice is that the very first thing right up front are the values of the company. And then you actually have to take a little test that tells the company what kind of employee you are. And that's really useful to them because it helps them put together teams that they send out on site for consultations. But it's also a really cool little thing that tells you that they value you as a human being. Are you creative, innovative, energetic? Are you careful? Are you risk averse? Who are you? You take a little personality quiz that they've designed. And then on your first day, there's like a little mug and a T-shirt waiting for you with your name and your characteristics on it. And it's kind of cute. But it's also a valuable exercise for team building, right? So you put all kinds of different important characteristics together when sending out teams. But that whole value-based focus is so important for the relational contract. And I think if more employers humanize the employment process like that, they would attract a different kind of employee. I'm still getting emails from people who've just been hired by Oricon saying, I hear that you made this contract. We love it so much. Thank you. It's really made me feel so positive about joining this organization, which is exactly what they wanted. This is what they said. I mean, they were knocking on my door. The wonderful John McGuire, who used to be their innovation officer, he was like, oh, this is what I want. I want law to stop being awful. He's an engineer, very blunt about law. They tend to be. It's like, law is just, it demonizes everything. Let's stop doing that. You're doing the one thing that I want. You're innovation law. Let's change it and make it about the spirit of that relationship. I'm like, okay, sounds a bit hippy-dippy, but let's go for it. And we did. And I think it's more pragmatic than it sounds.
I love that. I think that's really, really interesting because it struck me, if you look at the recruitment process, on the one hand, you've got companies that are bending over back, present an image, right? They spend money marketing themselves, right? And recruitment. And if you think about graduate processes, a ton of money is spent on kind of making it look attractive. You then get the crappy bit, which is the read this contract, sign here, get this over. No, you have to do these things. And then we move into the sort of the training bit where.
So let's go back to the training bit. But before we do that, let's look at what's in that contract. If it's a standard form employment contract, it's got horrible clauses about your resignation, about what you cannot do, about how if you go anywhere else, you cannot take your clients with you or engage in any similar business like this ever. It's got some really punishing behavioral norms in there that nobody in their right mind would ever dream of actually pursuing if it happened. So many of these draconian employment clauses, and this is something that I'm so proud of, both myself and Robert Joy have been comparing notes. So many of the draconian clauses have hit the cutting room floor. The moment we start to illustrate them or unpack them in plain language and communicate to the employer, this is actually what you're telling your employees, like, we would never actually maintain that, uphold that. This anti-competition clause is vile. Would we ever do that? Then I have them go back and do the risk assessment. In the 37 years that we've engaged in business, this has happened to us twice and we've chosen not to pursue it. Why the hell would you then have it in your contract? Why?
Right, because it's not. What I find interesting about that is it's not just a case of, here's some unnecessary words that we can strike through. Here's some cartoons we don't have to draw. It's actually sending a signal to the people joining it, going, this is the sort of company we are, right? And it's like this hidden that if you do these things, we will pursue. That is what we're about, and we don't trust you because that's why we have to include those things in there.
So they've hit the cutting room floor. More often than not. In fact, I don't think I've got a single employment project I've worked on where any of that has been kept in, which is fantastic. It's all gone because they would never uphold it anyway. So what's the point? And it's just plain old nasty. So if they want to be relational about the established relationship, then hey, let's cut out the really nasty. That's not to say that we don't have nasties in there, and we do. And if you look at the Oricon contract, there's one about serious misconduct, which, by the way, psychological tip here, is the only one where the avatar of the company is bigger than the avatar of the employee. He's big and red and there's steam coming out of his ears. The little Oricon Bobby, as we call him. Other than that, he is nice and unthreatening and cute and cuddly like the Stay Puft Marshmallow Man that inspired him.
But that's a fascinating thing, right? Because you sort of say, so there's this sort of practical question, would we ever do this? And you can have that discussion by looking at the written. So you could draw that conclusion if you were just reviewing a text-based version of a contract. But what's interesting about what you were talking about is that you have that as well. But then you say to yourself, okay, how are we? What is this going to look like? What's the picture here? What's the image that this gives? And literally, I think the word image is interesting because you're taking what's the image, what's the impression of the company that we're, and transforming it into art actually forces you. So if you were to do that, how would you represent that? It wouldn't look good. And so all of these words that we use about image wouldn't look good. All of that sort of language.
It very literally doesn't look good.
Right. And I think it's fascinating because what you're doing is pulling, and that tells us that this is a basic human thing. It's sort of like, let's have a look. How does this make us look? Well, the answer is not very good because we'd be drawing something that wouldn't, and therefore that's the impression you're giving people that are joining your company. Is that really what you want to do? So it's a nice bit of self-policing. Yeah,
and we look at the history of this, very large global company, and we get feedback from some of the lawyers and external and internal in-house and outhouse. Sorry, not an outhouse lawyer. I'm in the profile there. Got to edit that out.
No, I'm leaving that in. That's
I'm not
brilliant.
saying that all large law firms are out-house lawyers. They're not in-house lawyers. But what they feed back to us is that, the one thing that they would consistently recommend that has and should be maintained is stamping down on serious misconduct. And so that's the one thing in the contract that we are happy to visualize, and this is where, boss man will get angry. Other than that, why does boss man have to be a bastard when historically it's obvious that they never will pursue this and they never will maintain this anti-competition clause, and they're not actually going to sue you for taking a couple of clients? Because let's face it, everybody does it.
Wow. So this is amazing because it's when you start to think about this subject, and my initial thing was, okay, that just makes it easier for people to understand.
It's much more than that.
But actually, this is so much more than that.
So much more than that.
And it's not just about, what the bit I think is really interesting is it's not just about the people that you're communicating to. It's actually the people that own the process internally have to reflect on their own efficiency. So it's almost there's a transparency on process and approach and communications that wouldn't necessarily come from trying to, let's make all of our policies 50% shorter, right? This is much more effective because you're really forced to think about what do we want to do. And so I think that's a very, very powerful psychological tool, not just for the relationship with the people, but actually for people thinking about what their role is and how they do it.
Very, very much so, which is why it's so interesting that we're so involved with the values of the company that we work with. I've had a couple of sponsors now who don't have identified values. I'm not saying they don't have values, but they've never really sat down and thought about what their values are. And we found that it's something that we just do as a standard now upfront. One of my colleagues here in Australia has designed this really cool AI engine where she can do values for people with her AI engine. Can't wait to work with that. Haven't done that yet. But the process of identifying these values is actually central to the nature of the illustrations, the nature of the selection process of what goes into the contract, and looking at that risk assessment as we sit down and do it, looking historically at what's gone wrong in the past, what's likely to go wrong, what's actually the real problem here, and what is it we need to change in terms of behavioral drivers. The values are all intrinsically a part of that, whether we like it or not. And I know it sounds really hippy-dippy, but it's not, because it's actually central to that relational contracting, which is the anchor around which we do these visual contracts.
And I think this idea of take marketing as a discipline and saying, well, look, what they do is relevant to a ton of other things, because actually we don't have a different present. We can. I think historically there was a view, and there was probably a time where you could get away with this, where you could go, well, we'll put this marketing stuff out there, right, and that'll be our image for that, and then the reality will be slightly different, but it doesn't matter. And there's that. And now with some of the social trends, but also the technological, where, if you are bullshitting your customers, right, not only will they find out, but they'll talk to each other about it. And so you can't get away with some of these things you used to be able to get away with. And I think this beautifully plays into that question of breaking down those silos of saying, actually, there isn't a difference between an external message and an internal one. It's all the same thing. And you might try, I remember ages ago when celebrities used to do ads in Japan, Western celebrities used to do ads in Japan for stuff that they would never dream of advertising because nobody would ever see them, right? So they get paid a ton of money for advertising something a bit weird. And you go, you can't do that nowadays, right? Because you'd be on the internet in seconds. And I think there's something similar about that with what you're doing. And so you're beautifully breaking it down and going, don't try and kid yourselves, right, that you're running some Dickensian workhouse internally and presenting this beautiful, fluffy image externally. Right, that doesn't work anymore, and I love this because you're pushing into that direction.
But sometimes it's not even. I mean, again, there you are with the willful, evil Dickensian workhouse. Sometimes it's not even a willful deception; it's just things that are actually happening this way. So you need to properly reflect those values because they're not necessarily evil, but if they're misrepresented, then they're going to come across as deceptive. That's the whole thing. It doesn't have to be evil from the onset, like a Dickensian workshop. It could just be that some processes, if misrepresented, are then perceived to be quite a negative light because that's not the expectation. So I think a lot of contractual getting it right is about managing expectations, which is why we put those values front and center. Because it's really important that those expectations are the same. If they're not, that's when you get in trouble. That's when you've got misunderstandings and ultimately potentially lawsuits because there's some serious issues that are misunderstood. Wow, thank you.
I'm so genuine. I love this and the passion with which you speak about this.
I'm a bit of a girl.
No, but I love it because you've come. The bit that I think is super powerful here is you've come from the discipline, right?
Yeah.
You're not somebody that's sat externally going, who are these idiots with their tedious contracts? We could do a better job, right? You've come from the thing, you know where that's come from.
Yes.
And you're going...
But I've sat in an ivory tower. To be fair, I haven't sat on a bench or in an office where I've had to work with clients for 20 years. I've sat in my ivory tower with the luxury of looking down on things and thinking, I wonder if we can do it better. But without ever actually having the chutzpah to do something about it. And then suddenly along comes this amazing idea. Why not do it? And I don't know if you've heard the story, Christian, but it was a late night in Brisbane that my my good friend Adrian Keating from engineering, he was so angry with the lawyers, and he was the one with the UWA Makers Unit that was in so much trouble because students kept talking about what they were working on with industry after signing NDAs that they hadn't read. And he was like, why does law have to be so fucking awful? What lawyers this, lawyers that, always demonizing good people, making everybody not be friends. And I literally just shouted at him, what the fuck do you want, Adrian, a comic book? And he was like, yeah, let's do it. So there you go. Too many cocktails in a bar in Brisbane can really get you in trouble these days. And 6 years later, we have this huge project, massive amounts of activity and impact.
That is awesome. I'll tell you what, that is just the best way ever to close out this episode of the podcast, because it's like, I think it encapsulates so many things, right? One is the spirit of creativity that's gone into this. And the second is, of course, that cocktails can be a good thing. In moderation, all that sort of usual disclaimer stuff.
You have to be careful with it.
But I think it really illustrates that this is born of frustration. And I think some of the most creative ideas come from, why the hell is it being done this way? And we intuitively know that it's not quite right. So I love that sort of that frustration on both sides that's created something beautiful and I think really, really interesting. And as you say, this has ramifications in all sorts of interesting ways. And you are the perfect advocate for it, because you just clearly you love doing this stuff. And I think you found a niche that is super powerful. I'm looking forward to seeing loads more of these things. But in the meantime, thank you so much for coming onto the podcast and being such an engaging guest. But secondly, for beginning to crack this massive nut that we all intuitively know is a pain in the arse, and you're starting to find solutions to it. So thank you for that as well.
Oh, thank you, Christian. It's been a pleasure talking to you. I'm happy to come back anytime.
I would love to have you back. I'll hold you to that.
So that's it for this episode of the Human Risk Podcast. My enormous thanks to Camilla for appearing and to you for listening. To find out more about Camilla's work, comic book contracts, and many of the other things that we talked about in the show, have a look in the show notes. There are links to those there. If this is your first time listening to the Human Risk Podcast, welcome. You can subscribe wherever you get your quality audio content. It's available on all of the major podcasting platforms. To find out about previous episodes of the show that you might have missed, visit humanriskpodcast.com. If you're interested in finding out more about my work with my clients, and in particular, how I am using the comic book contract thinking in the fields of ethics and compliance, visit human-risk.com or get in touch with me. I'll be back with another episode of this show very soon, but in the meantime, stay safe, enjoy your comic books, and thanks for listening.